whether the complaint recites facts constituting the charge offense. Not rhetoric, not labels, or even policy disagreement. Dapat ito po ay talagang facts. O yun lang po muna. Yun po yung una kong gusto sabihin at meron pang kasunod yan. At gusto kong ipangako sa ating Madam Chair, hindi po ako magwo-walk out this time.
Thank you for your passionate
Madam Chair.
manifestation. In response to the manifestation of the Honorable Abante,
Yes, Madam Chair.
the Honorable Co is recognized.
Okay. Thank you, Madam Chair. Just quickly responding to the previous manifestation, any jurisprudence that cites that yung complaint has to be supported by more than mere allegations or bare allegations. Dahil yan ay galing sa decision of the Supreme Court, ibig sabihin dumaan na po yan sa trial stage at nahanap sa trial na walang evidence. Pero to reiterate, wala pa po tayo doon. Nasa stage pa lang po tayo ng determination of sufficiency of substance. Kung ang allegations sa complaint, if you take it one by one or the whole, would constitute an impeachable offense. So, meron pa rin talagang pag-deem na hypothetical admissions ang ginagawa natin, granting na totoo yung lahat ng mga sinabi ng complaint, meron bang betrayal of public trust na nagaganap? Once again, to remind lang po the committee and the body na nandun pa lang po tayo, hindi pa po tayo pumapasok dun sa sa pagsiyasat, the truth of the allegations. And anyway, kaya naman po hinahain dito dahil may confidence yung complainants na kapag we delve into that and we're able to present evidence and we're able to call on witnesses, they're able to submit affidavits, meron pong truth na malalabas. Madam Chair.
Thank you. The manifestation or response of the Honorable Co is noted.
Madam Chair, since nabanggit po yung pangalan ko,
The Honorable Erize.
yes, gusto ko lang po, very, very short. Gusto pong liwanagin na wala pa tayo sa stage ng pagpipresenta ng ebidensya na tulad ng sinabi ni Congressman Abante. At yung pong mga sinabi niya na parameters para sa determination ng prima facie ay lahat po binanggit ko. Who? Presidente. What? Yung pong pag-aproba niya ng release ng mga unprogrammed appropriations at pagpayag niya na tanggalin yung mga flagship projects na nagresulta sa pagkalugi ng gobyerno. Pangatlo, when? 2023, 2024, at 2025 national budget. How? Ayun po, yung pagpirma niya. Yun yung importante. At 3 taon. Kaya po, ma-relink natin ito sa isang paglabag, kung tatawagin ko po ito, inexcusable gross negligence. Matinding pagpapabaya. At ito po na particular na offense na ito ay pumapatak sa betrayal of public trust. Yun lang po. Salamat po.
The manifestation is noted. At this juncture, we recognize the Honorable Rufus Rodriguez.
Thank you, Madam Chair. Specifically, the first act or the first ground to impeach the President is under page 18. Charge, paragraph 66. Respondent President Marcos betrayed public trust by institutionalizing a scheme of corruption through the baseline balance parametric formula. That is the charge. That's not the recital of fact. That's the charge. So I expected, that after 66, there will be recital of facts that will be able to state in ultimate facts the acts of the President institutionalizing the Pbbm formula. This is from page 18 to page 23. A clear reading of all the paragraphs here does not even an iota of recital of fact that there is a connection. There is an act of the President to institute this particular formula. How will the President institute something in this country? Administrative Code of 1986. It says the President issues presidential proclamations, executive orders, memorandum circular. There is no recital of fact here that the President has issued such orders are provided for in the Administrative Code of 1986 that institutionalizes the BBM formula. Second, it can be done through indirectly. There is no recital of fact here that the President called officials of the public works of Malacanang to tell them to institute this formula. Nothing recital of fact that the President did the act of institutionalizing under the Administrative Code or even indirectly. No recital of fact on that. Now let us go to the particulars. These are now their alleged recital of facts. Page 18, 67 paragraphs. Paragraph 67. About July 2022, with the first month of assuming the presidency, the DPWH adopted, that is their statement, adopted the BBM parametric formula. Because indeed, the Department of Public Works originated, planned, discussed, implemented this formula. Where is the President here? In the planning, in the implementation. No, there is no statement here that the President directed them to adopt a formula. This was solely adopted, Madam Chair. This was solely adopted by the DPWH. And so, this particular of deliberate design of corruption mechanism certainly does not recite a fact to prove, to be able to state that there was institutionalization of this formula. Now, let's go to the others. Because clearly, it is a formula done solely by the Department of Public Works and Highway. Next, B. Let's go to B, page 20. Let us all go to this. Concentration of contracts, 100 billion to 15 billion favored contractors. Where is the statement here that these contractors were directed by the President to Public Works to be given? In fact, Madam Chair, the President himself was the one who exposed these 15 favored contractors, and thank God there is no favored contractor, these 15 in Cagayan de Oro 2nd District. That is why, Madam Chair, this is not a recital of fact to support the institutionalizing of this formula from the President. Next, geographical misallocation given to Bulacan, Oriental Mindoro, Tarlac. Is there a link that the President ordered that this be given to them? None whatsoever. This was all the function, implementation, and planning by the DPWH. So this geographic misallocation are statements which are irrelevant to the institutionalizing. That is the charge, institutionalization. So therefore, this will fall. There is no sufficiency here in the recital of facts. Then we go to D, betrayal, abandonment of the public good for private enrichment. Here, we can see here that once again, the systemic betrayal has no recital of fact that will show the President's involvement in this particular formula. And then, they go to the conclusion. My goodness, in a complaint, you don't have a conclusion. In a complaint, it already clear it's not a recital of fact because you state conclusion, corruption was systematic, not incidental. Conclusion of law not based on fact. That is on page 22. That is paragraph 92 to 93. And then we go to page 23. Now, legal conclusion. Now, these are now conclusions of law, which we will all disregard. Because when we go to a complaint, we go to the ultimate facts constituting the offense charge. So therefore here, it concludes, conclusion of law without any basis. It says, respondents Marcos institutionalization of the BBM parametric
Di
formula
naman po
constitute betrayal. There is no link. Their conclusion jumps from the charge, paragraph 66 to paragraph 94 without any link of the President. And that is why, Madam Chair, clearly, the first ground of betrayal of public trust is not sufficient in substance, and this particular allegation should fall. Thank you, Madam Chair.
Thank you, Honorable Rodriguez. At this point, we recognize the Honorable Janice Digamo. We are still on the first offense, institutionalizing systemic corruption through the Pbbm parametric formula of allocables. You may proceed.
Yes po. Good morning to everybody. I would like to express how I understand the procedure, lalong-lalo na doon sa unang grounds na binabanggit. At being a non-lawyer, I have to aralin po kung paano ko titignan yung sufficiency in substance. And sa akin pong pagre-research, lalong-lalo na ngayon na narinig ko si Congressman Rufus, pag ina-assess natin yung sufficiency in substance on the first allegation, natutunan ko that I have to look for the act, the document, and the violated duty. So dun sa first allegation, yung BBM formula is the act, but you will have to ask the question, who committed the act? Is it the President himself? Alam po natin, in-explain po ni Kong Rufus na hindi naman po. Ano yung document to support it? Nandun ba yung document to support the allegation? Dapat hinahanap natin yan pag nagja-judge tayo according to the sufficiency of substance. At ang pangatlo po, yung violated duty. With the BBM formula, and yung implementation has nothing to do with the office of the President or the President himself. Paano magiging si Presidente ang person to be blamed para dito sa sinasabi natin na BBM formula? You cannot see the hand of the President in all this accusation. Lalong-lalo na dito sa unang sinasabi nila ni BBM, the BBM formula. I think we have to go back to DPWH dahil sila yung nag-i-implement ng programa. Pwede kasi na ang intensyon ng Presidente for giving the budget is very good. Pero yung nag-i-implement ang nagiging problematic. So saan yung kamay ng Presidente doon? Yun yung hanapin natin dapat. So yan lang po. That's my peace of mind, Madam Chair. Thank you po.
That manifestation of the Honorable Digamo reminds the Chair to encourage the members to speak in a language where we will be understood by our beloved countrymen, no? This is actually the power of the sovereign people, and I hope that through this public hearing, we are able to communicate where this power truly rests, no? So we encourage the members as much as possible to speak in Filipino so the people will understand us. Thank you, Honorable Digamo. This is still on. All right. In response to Honorable Digamo,
Yes.
we
On
recognize
the
the
comments
Honorable...
made by the Representative Rodriguez and Representative Digamo.
All right.
As well as earlier, the Representative
The
Navas.
Honorable Ilago is recognized.
Yes. Madam Chair, tungkol doon sa first act ng betrayal of public trust, doon sa pagpapatupad, pag-implementa ng sistematiko na korupsyon sa pamamagitan ng baseline balanced managed parametric formula of allocables. Ang charge po doon sa complaint nakalagay na ang respondent, President Ferdinand Bongbong Romualdez Marcos Jr. betrayed public trust by institutionalizing a systemic scheme of corruption through the adoption and implementation of the so-called baseline balance managed parametric formula as the official allocation mechanism for flood control and other infrastructure projects, thereby converting the national infrastructure budget into a centralized apparatus for plunder. Kanina pa ho sinasabi na DBM naman ang nagsulat niyan, DPWH naman ang nagsulat niyan, ang author, DPWH naman ang nag-implement. No? Pero ang hindi po sinasabi dito, no, sa ilalim din ng ating konstitusyon, ng ating saligang batas, Section 17 of Article 7, the President shall have control of all the executive departments, bureaus, and offices. He shall ensure that the laws be faithfully executed. And corollary to this is the doctrine of qualified political agency, aka the alter ego doctrine, which the Supreme Court explained that the President's power of control is directly exercised by him over the members of the cabinet who, in turn, and by his authority, control the bureaus and other offices under their respective jurisdictions in the executive department. Ang bottom line, Madam Chair, tulad ng nabanggit din ng ating mga complainants doon sa nakasaad mismo sa complaint sa paragraph 67, page 18, na noong July 22, 2022, noong first month pa lang na nag-assume ng presidency si Pangulong Bongbong Marcos, ang DPWH nga ang nag-adopt nitong BBM parametric formula bilang official methodology for allocating the unprecedented 545.6 billion in flood control appropriations mula noong 2022 hanggang 2025 no budgetary cycle. Nandyan din ho paragraph 92, page 22, yung alleged kickbacks na predictable at intended consequences ng institutional design choices mismo ng respondent sa pamamagitan ng BBM parametric formula. Paano, Madam Chair? Ang bottom line dito, yung mga written internal policies na adopted and implemented by the agency by virtue of the qualified political agency, siya po dapat yung lahat ng ito ay attributable mismo sa presidente. Unless meron talaga siya na express, no written, na nagsasabi na ito ay kanyang hindi inaaprubahan. O ito ay or merong disapproval mismo ng presidente. At yun yung hindi natin nakita. Bagkus, nakita pa natin na ito ay nagpatuloy at nag-cause ng malawakan, sistematiko na korupsyon na nagbigay daan doon sa malawakan na pagnanakaw sa pondo ng ating bayan. Kaya, Madam Chair, kami po ay naninindigan na merong personal na involvement, ito po ay may basbas ng Pangulo at hindi ito magiging posible kung hindi mismo pinayagan, sinusugan ng Pangulo mismo.
The manifestation of the Honorable Ilago is noted. Our
Madam
last
Chair.
speaker for the first offense, the Honorable Padiernos.
Madam Chair, and afterward.
Let us finish first with the manifestation of the Honorable Padiernos, and then we will be calling the Honorable Ko.
Thank you, Madam Chair. So, just a quick manifestation. Madam Chair, after carefully reviewing the complaint and with respect to the first allegation on the so-called Pbbm parametric formula, this representation is in the position that the allegation is insufficient in substance. Una po, walang batas at walang jurisprudence na nagsasabing illegal ang paggamit ng isang budgeting or allocation formula. Pangalawa, wala ring ipinakitang dokumento na nagsasabi na personal na nilikha o inutos ito ng Pangulo. While the recital of facts could possibly constitute the offense charged, the allegations do not point that as to the formula, the same is attributable to the President. The allegation in paragraph 91 stating that, and I quote, the scope and scale of this corruption spanning multiple senators, cabinet secretaries, undersecretaries, district engineers, contractors, and intermediaries could not have operated without the institutional architecture created by the respondent, is at most presumptive or speculative. Even if cabinet secretaries are alter egos of the President for purposes of executive control, the doctrine does not automatically convert every administrative issuance into a personal culpable act of the President. In this case, the complaint does not allege that the President directed, approved, ratified, or even knew of the question policy much less that he acted in bad faith. Malinaw po to sa ating jurisprudence under Estrada versus Desierto and Gutierrez versus House Committee on Justice. Impeachment requires a personal overt act and culpability. The alter ego doctrine cannot supply what the complaint fails to plead. Dahil walang illegal act na na-plead personally against the President, this does not constitute an impeachable offense. Again, Madam Chair, I just want to reiterate, the recital of facts as mentioned for the first allegation could possibly constitute the offense charge or betrayal of public trust in this case. But we have to also consider, does that offense, is it personally attributable to the President himself? And this representation is in the position na in the negative po. So yun lang po, Madam Chair.
Thank you, Honorable Padiernos. Now let's hear the comment from Honorable Ko.
Thank you, Madam Chair. Madam Chair, just to reiterate the discussion of Representative Sara Elago, we talked about kanina yung doctrine of qualified political agency. Ito ay well-established in jurisprudence. Ang sinasabi lang naman po nito, yung acts of department secretaries, presumed yan na acts of the chief executive or the president, no, unless disapproved. At ang may burden ng showing kung may disapproval man or hindi, nasa challenger, no. So una po, nasa attachments po natin yung tinatawag na BBM parametric formula. This is a 16-page document which says, no, that this formula was used para i-prepare ang 2023 National Expenditure Program. At ano po yung act of the executive that validates yung use of this formula? No? It is the signing of the NEP. In fact, kung i-extend pa natin, no, meron pong, we could take judicial notice of the claim by now DPWH Secretary Vince Dizon that in the preparation for the 2027 NEP, they will not be using the BBM parametric formula anymore. That is an implied admission na even up to the 2026 NEP ay ginagamit pa rin po yung parametric formula na ito, which says that the priorities of leaders of the national government will be considered in approving infrastructure budgetary allocations, no, yung matatawag nating allocables. In fact, meron din po tayong attachments in the complaint which says, no, and tags NEP items. They are for OP, ES, SAP, indicating presidential involvement in implementing the formula for allocables. So ibig sabihin po, this presumption, no, may presumption na itong act ng secretary na doon po sa formula, clear po sa document na galing po to sa Office of the Secretary. So we assume na act po ito ng President. And then yung act of the President of signing the GAA 2023 onwards validates po yung use of the formula. Yun po ay alleged in the facts of the complaint that is recited. And so ito po yung pinopropound natin, no, na at the end of the day, may tag budget items and NEPs and allocables for OP, and thus, no, magsastand po yung argument. Thank you, Madam Chair.
Madam Chair.
Madam Chair.
Madam Chair.
The Honorable Rodriguez and then the Honorable Abante.
The doctrine and the presumption of qualified political agency was pronounced by the Supreme Court in the case of Planas versus Hill, Mondaño versus Helvosa. I cannot forget that first year law school. And in that case, precisely it's a presumption because then it can be rebutted by evidence. Now, it would have been incumbent on the complainants that they will be able to strengthen this presumption by putting up a link of qualified political agency, alter egos of the president in terms of implementation of the public works to implement. He is the alter ego being a secretary. That is a presumption that everything is done correctly. Now, it would have been incumbent of the complainants to be able to show and strengthen this presumption by saying that this particular qualified agency was in fact directly, it's not anymore a presumption because they're alleging that it is direct. It is not anymore presumption because they are now charging that there is institutionalization. So therefore, the case of Planas versus Hill and Mondaño versus Silvosa, they can research that now because I just remembered it. First year law school. Now, therefore, they cannot hide now, the complainants cannot hide now under the cloak of that presumption because they are now filing a case against the president. And so therefore, everything in the face of the documents there should be a recital of facts. So the presumption cannot hold anymore because they are now filing the case. And they are now saying that this is not only a presumption, it is done and it is what is that the president is linked to the institution, which there is no recital of fact on that. Thank you, Madam Chair.
Thank you. Next is the Honorable Abante.
Madam Chair, the explanation of Congressman Rufus is actually more than enough. No, pero I'd like to add to this. No? Ito naman tinatawag nating the doctrine of command responsibility, where we say that the act of the secretary is the act of the president, and the act of the department heads is the act of the secretary. Ano ha? Yan po'y general rule eh. General rule po yan. But there is always exception to a general rule. For example, sa akin po sa akin, alter ego is not immunity. But also not strict vicarious criminality. Unlawful acts are not acts of the state. And liability analysis remains individualized for wrongdoing. Kaya nga po iniimbestigahan pati ang Secretary Bonoan eh. Kaya nga po tinanggal Kaya nga po may kaso. Bakit pinabayaan ng ating Pangulo na kasuhan niya mga yan? Kung siya po ay talagang author ng lahat ng mga nangyayaring yan. Therefore, ito po itong number 1 na ito, the argument na binigay sa atin, with due respect to Congresswoman Sara, at po na mga talagang mga close din sa akin to mga to. No? Pero the thing is this po, kinakailangan malaman po ng taong bayan na hindi po ito yung absolute rule. General rule po ito. At naniniwala po tayo na ang unlawful acts ng sino mang alter ego ng Pangulo, hindi po ito act ng Estado. Kaya nga po ito'y iniimbestigahan. Kaya nga po naniniwala ako na hindi po ito nauukol sa tinatawag nating sufficiency of substance. Thank you, Madam Chair.
Madam Chair. Madam Chair.
The Honorable Tino.
Thank you, Madam Chair. Maikling mga manifestation lang po. No? Una po, malinaw at direkta po ang recital at pakahulugan dun sa unang bahagi ng betrayal of public trust, institutionalization ng allocables at sistema ng corruption sa pamamagitan ng Pbbm parametric formula. Ano po ang akto? Malinaw na po kahit dun sa title mismo, high level ng dokumento na kasama po sa mga attachments at official na dokumento ng DPWH. High level budget allocation formula, the baseline balanced managed parametric formula adopted in 2023 National Expenditure Program preparation. No, yung National Expenditure Program, yun po, ang tawag nga po dyan, the President's Budget. No, so ito yung budget na nilalagdaan ng Pangulo at sinasubmit sa Kongreso at itong nagiging batayan ng General Appropriations Bill. So yun po yung malinaw na sinasaad dito na ibig sabihin ng institutionalization ng sistema ng korupsyon. At nais ko lang pong ipaalala na hindi lang naman po yung policy na yon ang batayan ng unang bahagi. Kasi sasabihin niya, policy lang naman yan. Anong masama dyan? No? Kaya nga po kasama rin po dito yung mga testimonya, sinight yung mga testimonya ng mga whistleblower, kasama si Yusek Bernardo at ilang mga kontraktor. At nandun din po sa complaint, sa attachments, yung mga records nun na nagsasabi na ito ang naging basis ng kickback, no, ng mga ghost projects, substandard projects, kickbacks and commitments. So yun po ang buong recital, kaya sinasabing may betrayal of public trust ang Pangulo. Yun lang po ang gusto nating ilinaw dito.
Of course, we value the long-standing principle of law, no? As a matter of fact, that qualified political agency is considered as one of the landmark cases, and you will agree with me. However, the Honorable Padiernos made mention about one jurisprudence which provides there has to be personal, overt, culpable act to constitute an impeachable offense. I would just like to give this chance to the Honorable Ko if she wishes to comment to that as well.
Thank you, Madam Chair. To us, no, it is clear na yung act na po yun is signing of the budget. No? Passing the budget and then later on signing the budget. Na ginamit po doon yung BBM parametric formula to be able to distribute yung system of allocations.
We note the answer of the Honorable Ko. So
Madam
that
Chair, I just wanted to add on
Honorable Padiernos.
the alter ego doctrine. Madam Chair, the alter ego doctrine only creates a presumption in terms of administrative purposes. It does not establish personal culpability for impeachment. Kasi kung ganun lang din po, di lahat na lang po ng cabinet memo na in-issue, kung nagkamali in the future, sinabing mali, lahat na lang po yan pala impeachable offense. So it sets a bad president or precedent that, if the president would be silent on matters like such as this, then automatic guilty na po siya. Parang ganun po yung dating. So yun lang po, Madam Chair.
Madam Chair,
Honorable Tino.
just reply to that. Yung sinaside po na jurisprudence with respect to delegated authority and so on, this is with regard to criminal liability. No? Pero ang pinag-uusapan po natin dito ay betrayal of public trust. Kaya nga, sabi nga kanina, acts that fall short of criminal acts. Kaya hindi po nag-a-apply yung binabanggit niya rito, no, dahil ang pinag-uusapan po natin ay acts that fall short of a crime, an actual crime. No? Yun lang po ang gusto nating ilinaw.
Thank you, Honorable Tino. And as our last speaker, last to comment on the first offense is the Honorable Digamo.
Thank you po, Madam Chair. Madam Chair, when the President affixed his signature, malamang po bilang Presidente, ang iniisip niya yun talagang this will do good. These projects, this fund will be translated into projects that will protect lives and properties. Inaasahan po ng Presidente na magiging maganda ang gagawin ng agency kung saan pinaglalaanan niya ng pondo. Bakit ko po ito nasabi na the allegation lack in substance? Because wag po nating kalimutan that during the SONA, the President himself called the attention of those hearing officials na sa paniniwala niya nagkandasira-sira ang maganda niyang plano dahil sa maling pag-i-implement po. I hope everybody in Congress will remember that ni-remind ng Presidente. Kaya hindi ko po makita yung kamay niya dito dahil siya mismo nag-remind kung anong ginawa niyo sa pinagkatiwala ko sa inyo. Thank you po.
This
Madam
should be
Chair.
the last of the last.
Yes,
The
Madam
Honorable
Chair.
Elago.
Opo, we cannot and should not speak for the President. Kaya nga po nananawagan ng taong bayan na maipasa ito pagdating sa sufficiency in substance na para magkaroon na tayo ng hearing, mapatawag yung Pangulo mismo at marinig mismo natin mula sa Presidente yung kanya pong paliwanag kung bakit po nahayaan itong malawakan na korupsyon sa pamamagitan ng adoption at implementation ng BBM parametric formula at yung mismong paglagda niya sa ating pambansang budget. Okay, thank you.
We will be terminating our deliberation on the
Madam
first
Chair.
offense. Of course, we recognize the efforts and contributions of the members for the valuable exchanges of opinions, including principles of law. That concludes our deliberation on the first offense. We will now move to the second offense. Second act of betrayal of public trust, abuse of discretionary power over unprogrammed appropriations. Now we elicit the opinion, position, comment from the members. The Honorable Adyong.
Thank you. Thank you very much, Madam Chair. Bismillahirrahmanirrahim. Madam Chair, I understand that the direction of the committee is to compartmentalize the issues or the complaints under the Massa et al. Complaint, Madam Chair. But allow me first to at least touch on the first issue that was discussed earlier. And I understand, Madam Chair, that many of our members here, many of the members here have already spoken and expressed their manifestation regarding the first offense or the first complaint that was discussed. So my approach, Madam Chair, on these complaints, on how I understand it, is based on not necessarily on a legal perspective, because many of us here in the committee, I understand, are non-lawyers. So our approach here is, first of all, we based our observation on what is guaranteed in what are laid down in the Constitution that would constitute impeachable offenses. Number two, based on how the public would perceive these proceedings. Kasi ordinaryo pong tao nakikinig po sa atin. Minsan po hindi maintindihan kung ano po yung mga pinag-uusapan dito, and we cannot fault them because, you know, these terms, recital of facts, admissibility of evidences, these are legal terminologies that we can often see and hear them during a regular court proceedings. So my position here, Madam Chair, in the way I approach this is based on coming from an ordinary, average-minded Filipino. Madam Chair, the allegations stated in the complaint, to me, do not constitute betrayal of public trust. In an alleged violation of public trust, the alleged acts must be short of criminal. Tama po yung sinabi po ng aking kaibigan, Congressman Tino. However, the allegations as to receiving supposed kickbacks imputes a commission of a crime. That is a substantial defect, to my view, in the allegation presented. Because number one, the chosen charge is wholly and fatally inconsistent with the alleged act. There's a claim of direct personal involvement, but the same is merely conclusory and unsupported by sworn statements, documentary evidence, or the personal knowledge of the complainant. Meaning to say, Madam Chair, if there's a complaint in the impeachment proceedings such as this, while we are actually appreciating the sufficiency of substance, there has to be at the very least a link between the alleged crime committed and the person that is being accused directly ordering these crimes. This is borne, Madam Chair, out by the superfluity of general accusations, assumptions, and inferences, and the lack of identifying dates, specific transactions, responsible officers, or any overt act personally attributable directly to the President. Wala sa complaint mismo, Madam Chair, ang mga personal at direktang aksyon ng Presidente na magiging basihan para sa nirereklamong charge. There is not even a direct allegation to explain how these alleged kickbacks reached the President. Madam Chair, hindi po dapat gamitin ang impeachment proceedings bilang fishing expedition at hindi maaaring gamitin para sa akin, as stated earlier by my colleagues, the mere essence of a principle of command responsibility lamang o ang policy decision bilang basihan ng impeachable offense without necessarily, again, linking the President to personally ordering his subordinates to craft a policy that would be considered a direct culpable of the Constitution, constituting therefore an impeachable offense. In fact, Madam Chair, the Supreme Court has stated that the betrayal of public trust must refer to direct and personal acts by the accused. Number one, basic, Madam Chair, is to establish bad faith. The complaint relies heavily on singular, unverified, and unsworn testimonies, Madam Chair. The alleged testimonies do not meet on any material point that would establish direct, personal, and intentional participation of the President. In the Supreme Court decision, Madam Chair, cited by the complainants, which held that special provision from the GAA was unconstitutional for being a rider and for impliedly repealing the Universal Health Care Act, the court also denied to pass on the liability on the Department of Finance. In fact, Madam Chair, individual justices in their decisions stated that the Department of Finance followed the challenged provision in good faith. So there's no culpability even if you look at the ruling of the Supreme Court. That the finding of good faith defeats, Madam Chair, the accusation of betrayal of public trust because the same requires attendant grave and serious bad faith. There is no factual chain of culpability kung pagtatagpi-tagpiin po natin ang mga ebidensya na sworn, competent, at admissible. Hindi may papakita na mayroong partisipasyon po ang Presidente. Yun po ang basic na tanong ng ating taong bayan. To allow such fragmented and legally infirm allegations to substantiate an impeachment complaint would dangerously lower the constitutional threshold for impeachment. It would weaken the impeachment process, as explained to us extensively by the able chairperson yesterday. To allow barefaced and unsupported claims which do not directly implicate the respondent as basis for impeachment would erode due process, weaken institutional safeguards, and expose impeachment to abuse as a tool for political harassment and, I'm afraid, Madam Chair, destabilization. For all of these reasons cited above, I find that the allegations, Madam Chair, with due respect to my friends, do not constitute a betrayal of public trust. Marami pong salamat sa Madam Chair. Magandang umaga po sa ating lahat.
Thank you, Honorable Adjong. Now we recognize the Honorable Lordan Suwan.
Prohibited by law. In fact, they are referenced in Section 35, Book 6 of the Administrative Code. And so, presidential approval of the release of these funds does not equate to discretionary indulgence. It is actually a requirement of law. And on another point, the complaint mentions extensively about the case of Pimentel versus House of Representatives. This is regarding the PhilHealth funds. Now, their reliance, the complaint's reliance on that case, I think, is misplaced. We must differentiate because that case addressed the constitutionality of a specific funding mechanism in the General Appropriations Act. It did not find any instance of presidential bad faith, corrupt intent, or personal enrichment, nor did it characterize the release of unprogrammed appropriations as betrayal of public trust. Let's remember that judicial invalidation of a budgetary provision cannot be retroactively transformed into an impeachable offense. A ruling against a budgetary provision is not a ruling against the president. Now, the complaint also mentions extensively about the increases in unprogrammed appropriations amounts. And it seems that the complaint would make it appear that there is a grand criminal design and it was the president who is behind all of this. But in my opinion, there is a much simpler explanation in the increase of unprogrammed appropriations. It might very well be a response to post-pandemic recovery. This is a simpler explanation of this increase. And also revenue contingencies or even disaster-related responses. And regarding alleged irregularities in the execution of projects, this cannot be directly attributed to the president, but can be attributed to guilty or erring implementing agencies and even contractors. So, for me, as to the alleged second act of betrayal of public trust, the complaint falls short, or it appears that there is an insufficiency in substance.
Thank you, Honorable Suwan. Next in line is the Honorable Amben Amante.
Thank you, Madam Chair. The complaint raises unprogrammed appropriation and alleged kickbacks, yet it fails to establish any direct link to the President. Walang claim that he received money or property. Walang claim that he personally benefited. Walang illegal transaction showing personal participation. Walang allegation that he ordered, joined, or colluded in any kickback scheme. References to unprogrammed appropriation do not lead ultimate facts, tying the President to corruption. At law, unprogrammed appropriation are valid under the Administrative Code and were affirmed by the Supreme Court in Bellica versus Executive Secretary. In short, mere pagkakadismaya with how funds were allocated cannot substitute for evidence of personal wrongdoing by the President. Madam Chair, mere policy disagreements, pagkakadismaya with budget outcomes, or speculative allegation cannot substitute for direct presidential wrongdoing. Without ultimate facts supported by clear and convincing evidence, the complaints fall short of the constitutional threshold for impeachment. The question we must ask are simple. Ano ba talaga ang ginawa ng Presidente? Where is the evidence? Where is the law? Until these questions are answered with proof, the charge cannot stand. Thank you, Madam Chair.
Thank you, Congressman Amben. For the guidance of everyone, all the members, we are still on the second offense. That is the unprogrammed appropriations. We have a list here, and next in line is, if he is ready, Honorable Emeng Pascual. You want to be called later.
Here, who are in the list? So that I can include, if I propose to include my name.
Yes. Next to Honorable Emeng is Honorable Alan T. And then Honorable Garbin likewise raised his hand. Honorable Laila de Lima, and then Honorable Rodriguez.
Madam Chair, can you include my name too?
Yes, Honorable Abante. So for the guidance of everyone, Honorable T, Honorable Garbin, Honorable de Lima, Honorable Rodriguez, Honorable Abante. For the information of the Vice Chair Dumogan. For the information of the committee, Honorable Alan T. is using a slide, 2 slides to aid him in his expressing his manifestation. Honorable T., you may proceed.
Thank you, Madam Chairperson. The rules of procedure in impeachment proceedings requires that an impeachment complaint be sufficient in substance before it may proceed. Sufficiency in substance demands a recital of ultimate facts and a determination of these facts, if admitted, constitute a valid ground for impeachment under the Constitution. Despite its length and extensive recitation of budgetary figures, testimonial excerpts, and policy outcomes, the second impeachment complaint fails to meet this constitutional threshold. Volume, however, is not a substitute for ultimate facts. The complaint relies on inference rather than personal knowledge, characterizes discretionary policy mechanisms as criminal conduct, and imputes the alleged acts of third parties to the President without pleading specific overt acts personally attributable to him. Allegations are based on hearsay and lack personal knowledge. Section 3, Rule 2 of the House Rules of Procedure in Impeachment Proceedings requires that a verified complaint be based either on complainant's personal knowledge or based on authentic records. A review of the complaint shows that its central accusations rest on the testimonies, interviews, and statement of third parties. None of the complainants allege that they personally witnessed the President ordered, approved, or participated in any alleged kickback scheme. The complaint repeatedly cites Senate testimony, media reports, and investigative narratives to support the conclusion that the President orchestrated a system of corruption. These sources merely recount what other individuals claims to have observed or inferred. Allegations derived from hearsay, no matter how frequently repeated, do not constitute ultimate facts and cannot support a finding of sufficiency in substance. Failure to allege any act personally attributable to the President. Notably, the complaint does not allege a single specific act supposedly committed by the President, despite sweeping claims of institutionalized plunder and betrayal of public trust. Impeachment is not a doctrine of vicarious liability. The President cannot be impeached merely because officials within the executive branch exercise discretion, nor because Congress later disagreed with how such discretion was exercised. Assertions that the President sits as to the top of the bureaucracy or that policies bear his political branding do not establish culpability. What the Constitution requires is a clear nexus between the President's own acts and the alleged offenses, a nexus that is entirely absent from the complaint, as borrowed from the term of Congresswoman De Lima.
We are waiting for your slides.
Yes. Policy disagreements are not impeachable offenses. A substantial portion of the complaint attacks the design and implementation of budgetary mechanism, including the so-called Pbbm parametric formula, the use of unprogrammed appropriations and fiscal prioritization decisions. These matters fall squarely within the budgetary process. The executive proposes with the submission of the National Expenditures Program, Congress legislation with the passage of the General Appropriations Act, and budgetary execution by the executive. As stated in the General Appropriations Act itself, unprogrammed appropriations are expressly authorized by Congress and may be availed of only upon the occurrence of statutory conditions and the required certification, underscoring that their use is conditional and not an exercise of unfettered executive discretion. Unprogrammed appropriations are not discretionary funds in the sense alleged by the complaint. The complaint itself cited special provisions on unprogrammed appropriations under the General Appropriations Act. As can be seen from the slides on the unprogrammed appropriations under special provision paragraph 1, A, B, and C, there are conditions that must be met before you can avail of the unprogrammed appropriations. One, paragraph A, there must be an excess revenue, new revenue collection, or those arising from new tax or non-tax sources, or approved loans for foreign-assisted projects, and only after certification of fund availability by the Bureau of Treasury. As can be seen also, Your Honor,
Point of
that-
order, Madam Chair.
yes.
There's a point of order from the Honorable Ko.
We just like we just like to clarify that the budget being I'm sorry, point of information rather than point of order.
If that is a point of information, then we should allow him to finish first.
Okay. Okay, thank you, Madam Chair.
All right. The Honorable T, please proceed.
Thank you, Madam Chairperson. Note that unprogrammed appropriations are standby and conditional appropriations that may be only used only upon the actual realizations of paragraph A, B, and C, and certification of fund availability by the Bureau of Treasury. Until these statutory conditions are met, the executive has no discretionary authority to release funds and is further limited by the purposes expressly approved by Congress under the unprogrammed appropriations section of the GAA. Can you show the next slide, please? As to the purposes. As you can see, there are purposes that these funds that can only be utilized for the following purposes as stated in the General Appropriation Act. The executive may not release funds absent the statutory triggers, nor may it divert funds to purposes not authorized by law. Accordingly, the use of unprogrammed appropriations after compliance with statutory conditions and certification requirements cannot be equated with arbitrariness, illegality, or impeachable conduct. To do so would conflate lawful budget execution with criminal intent and collapse the distinction between policy implementation and constitutional violations. Disagreement with fiscal allocation priorities constitute a political or policy dispute, not a culpable violation of the Constitution. To accept the complainant's theory would be transformed impeachment to a mechanism for penalizing governance actions, thereby collapsing the separation of powers and undermining the constitutional design. There is failure also to state a cause of action for betrayal of public trust. The complaint invokes betrayal of public trust as catch-all ground for a collection of administrative grievances and political accusations. However, jurisprudence requires that this ground involved acts so grave and outrageous that they strike at the very core of public office. The complaint fails to allege any document signed by the President ordering unlawful disbursement, any transaction in which he personally received funds, or any commission on audit findings identifying him as a participant in illegal activity. General references to COA observations, Senate inquiries, and media reports do not amount to ultimate facts. The complaint relies on ongoing investigation and Senate inquiries to supply evidentiary support for several allegations, demonstrating that it's not evidentiary complete at the time of filing. Impeachment is not a discovery mechanism. A complaint must be sufficient in substance at the time of filing, not after hearings, subpoenas, or political inquiry. In sum, the second impeachment complaint is long on rhetoric but short on ultimate facts. It relies on hearsays, conflates policy disagreement with impeachable offenses, and imputes the alleged acts of others to the President without pleading direct participation, and are contradicted by the official records such as the General Appropriations Act. To allow such complaint to proceed would erode the constitutional safeguards governing impeachment and reduce it to a tool of political contestation. For failing to meet the rigorous standards of sufficiency in substance, the complaint should be dismissed. Thank you, Madam Chairperson.
Honorable T, would you like to reiterate your argument in showing the purposes in the slide?
Well, the purposes of showing the slides on unprogrammed appropriation shows that there are conditions to be met before one can be, before the unprogrammed operation can be availed. So there are conditions to be met as provided for under paragraph 1A, paragraph 1B, and paragraph 1C.
All right.
Likewise, Madam Chair, if I may proceed.
Yes, please continue.
Also, as to the increase on unprogrammed appropriation, the complaint itself in page 9, paragraph 28, and if I may quote, on December 11, 2023, this is in reference to the GAA General Appropriation Act 2024, the Bicameral Conference Committee, referring to Congress, submitted a report that drastically altered the President's original proposal, meaning the increase in the unprogrammed appropriation from the proposed 281.9 billion to a staggering 731.4 billion, an increase of 449.5 billion was through the act of Congress. Likewise, in the very same complaint, to fund this explosion, as I quote, the committee, referring to the Bicameral Conference Committee, inserted a special provision 1D, authorizing the use of fund balances of government-owned and controlled corporation. Meaning, Madam Chairperson, it's not the President who increased the allocation of the unprogrammed appropriations. It is the act of Congress by the Bicameral Conference Committee that increases the budget allocation in the unprogrammed appropriations. Thank you, Madam Chair.
Thank you, Honorable T. Your quite lengthy manifestation is duly noted. Now we recognize the Honorable Garbin. There's a list, Honorable Chua. You will be after the Honorable Abante.
Thank you, Madam Chair. Let me proceed with my manifestation on ground number 2. The expansion and use of the unprogrammed appropriations as a shadow budget. The core allegation of the complainant is that the UA, or the unprogrammed appropriation, grew dramatically. Releases supposedly required presidential approval, and therefore, the President personally enabled the corruption. Why is it not sufficient in substance? First, Madam Chair, as correctly put up by Congressman T, the UA is a statutory budget mechanism enacted by Congress. The UA exists because Congress places it in the General Appropriation Act. The growth in the UA by itself is not unconstitutional. The complainant or the complaint does not plead which constitutional limit was violated merely because UA amounts increase. Number 2, no pleaded facts identify any UA-specific release that was illegal. The complaint cites aggregate figures and percentages, but does not identify. First, the specific UA item release, the condition precedent for the release, how those conditions were absent, and the issuance of the SARO or the NCA that prove its illegality. Madam Chair, even assuming the Supreme Court, in the case of Pimentel versus House of Representatives, found parts of the 2024 budget mechanism unconstitutional, that ruling does not establish an impeachable offense by the President. In the Supreme Court, dispositive portion ruled that the presidential certification of its urgency as not unconstitutional. And even if it were for the sake of argument, Madam Chair, such act in itself does not amount to an impeachable offense. It is just merely a democratic mechanism of checks and balance. The case addresses the special provisions, specifically paragraph 1D and its DOF implementation. It does not supply the project level facts procurement irregularities, the kickback transactions, or any willful bad faith. The complaint still asks the committee to jump from unprogrammed appropriations figures to corruption conclusions without the required linkage. On that basis, it remains, Madam Chair, that this allegation is insufficient in substance. Unconstitutionality of a provision is not by itself betrayal of public trust. Betrayal requires pleaded ultimate facts showing grave misconduct attributable to the President. The complaint uses unprogrammed appropriations, expansions as an insinuation, but it does not show willful bad faith, corrupt purpose, or direct presidential participation, nor does the SC ruling fill those gaps. Madam Chair, thank you.
Thank you, Honorable Garbin. Next in line is the Honorable De Lima.
Thank you, Madam Chair. Before I present again my own analysis of the second ground, I wish to state these observations. Well, one or two of the previous speakers again dwelled on the entirety of the complaint, and that includes the Honorable Representative Zia Alonto. And I cannot also help observing that about a couple of the previous speakers are actually dealing with the defenses, the possible defenses on the part of the respondent. Yung pagkakasabi po, with due respect to the Honorable Congresswoman Degamo, that the President must have been motivated by the desire to address the public good. That is a defense. Another one is on the part of what was stated by the Honorable Representative Suwan, that the increase can very well be, may be explained by the fact that this was during the pandemic period. Again, that is a matter of defense. Kaya nga po, paulit-ulit ko pong sinasabi sa lahat na analysis ko po, nang tinitingnan lang po natin dito is the sufficiency in substance. And then, just to also address the point of the Honorable Congressman Ting, he pointed to paragraph 28. On December 11, 2023, the Bicameral Conference Committee submitted a report that drastically altered the President's original proposal. So his contention is that it's not the act of the President, but the act of Congress through the Bicameral Committee. Pero hindi ho ba meron allegation sa complaint? And I think this is pages 40 to 41. I'm sorry, paragraph 40 to 41 and paragraph 50 to 51. Ang natatandaan ko pong nakasabi dyan, during the Bicameral Conference Committee deliberations in 2024, PBBM instructed DBM Secretary Amena Pangandaman to insert 100 billion worth of projects during the BICAM. Another allegation, related allegation, PBBM produced a list of projects worth 100 billion for insertion. This list was given to executive and legislative officials involved in the BICAM. So nobody can really say that the President's hand is clean with respect to those insertions, additional amounts included in the GAA as deliberated upon by the BICAM. So again, allegation. Hindi ko po sinasabi, totoo yan. And then, nakikita ko rin po sa discussion under ground 2, page 25 and page 26, or even part of 27. The complaint actually made a causal link to corruption. Meron po sila mga diniscuss dito. Several circumstances, which include the allegation that the top UA-funded contractors are now under criminal investigation. Kasi sila po yung mga supposedly reveal ng Pangulo, pero sila yung mga top UA-funded contractors. And these 4 contractors yung Sunwest Silver Wolves Construction Corporation, High Tone Construction, Newington Builders received a combined 18.44 billion in UA-funded contracts. Funds released only
Madam Chairman.
because respondent
Madam Chairman.
personally approved the special budget authorizing
What
this
is the
disbursement.
pleasure of the Honorable SDML
With
Defensor?
due respect to the Honorable De Lima, may I raise a point of order?
You're recognized, SDML.
I respect the position of the Honorable De Lima, but we must also remember that every impeachment complaint, every impeachment hearing, regardless of who the respondent is, it is a political process. It is political in nature. And let's allow the members to speak what they have to say. We will not interrupt any member. We will not interrupt the Honorable De Lima. Let them manifest what they want to say, even the endorsers themselves. Let them speak. Surely we will finish this. But since this is a political process, let's allow them to say what they have to say and vote on it later on. That's all, Madam Chair.
We extended liberality to all the members in the same way that we are extending liberality to the Honorable De Lima. I think that's fair enough.
Thank you, Madam Chair. I don't think I'm in any way violating that rule because I'm not interrupting anybody here.
You're not violating any rule. I'm
Yes.
just saying that let the members speak and let them say what they have to
Thank
say.
you. Thank you for that.
The manifestation of SDML Defensor is duly noted as well.
So ang sinasabi ko na naman po dito, naniniwala ako na meron talagang mga allegation, factual allegations that would constitute the ground for impeachable or would constitute impeachable offense. Nasabi ko nga po kanina, per the rules, dun lang tayo dapat nakatuon. Yung mga defenses, let the respondent himself raise those defenses in the proper time. That is sa answer o kaya sa rejoinder, kung gusto pa rin mag-rejoinder, kung merong reply ang complainant. So, yung iba po kasi mga naririnig ko sa mga sinasabi for the previous speakers, defenses na po sila. Why can't we not focus our attention to the specific allegations? Later, at the end of the, pag natapos na po natin yung third ground, I can point out to those specific allegations. Ayaw ko lang po kasi mag-touch on the entirety of the complaint. But at this point, I want to say na yung factual allegations para sa akin, dun sa tatlong complaints, ay sapat. So, tungkol naman po dito sa second ground, may I now again present my analysis. Ang sabi po, Pbbm abused release of 213.8 billion of unprogrammed appropriations. Factual allegations. Although, sinimulan muna po ng parang isang treatise on the legal nature of UA or unprogrammed appropriations. So may discussion muna tungkol sa kung ano ang mga limitasyon ng UA. Of course, these are not allegations of specific facts, pero hindi ibig sabihin wala ng factual allegations under this ground. It may look like to be a legal memorandum yung pagkakadiscuss sa second ground, pero sa tingin ko po, there are sufficient factual allegations that appear to establish a nexus with the ground for impeachment. Corruption, which is betrayal of public trust. Remember, isang general ground lang po ang rini-raise dito sa impeachment complaint. The second, the Maza et al. Complaint. And that is betrayal of public trust manifested in three specific grounds. 3 grounds. Pero, betrayal of public trust kasi is all-encompassing. Pwede nating sabihin na lahat ng iba na mga grounds, whether it's culpable violation of the Constitution, treason, bribery, graft, and corruption, ay kung tutuusin po, kung titingnan natin, these are all constitutive of betrayal of public trust. Kaya nga po, naiintindihan ko kung bakit yung complaint ay only alleges one general ground. So again, ano pa po yung mga factual allegations? SC declared unconstitutional the transfer of 89.9 billion PhilHealth funds as grave abuse of discretion. That is a sufficient allegation. Another, Secretary Recto admitted identification of PhilHealth fund use for UA. Sufficient allegation. Another allegation, diversion of PhilHealth funds to UA used for flood control projects was the mechanism for kickbacks. Constitutes a raid of the nation's health fund by Pbbm. Ito po, this is a conclusion. Another allegation, top UA-funded contractors are now under criminal investigation. Sufficient allegation. Nakasama sa discussion doon sa causal link to corruption, which was laid down on the text of the impeachment complaint. Another, Pbbm authorized release of 213.8 billion of UA for infra. 111 billion was for FCP selected in accordance with leadership priority under parametric formula. Sufficient allegation po ito. The selection criteria used, though, included the parametric formula, which is a conclusion actually instead of a factual allegation. Katulad din po yung sinabi ko with respect to ground number 1. There may be statements of conclusions or conclusions of facts, but it does not change the fact, the evident fact, that there are factual allegations na merong nag-establish ng nexus. Another, amount of UA quadrupled from amount of unprogrammed appropriations quadrupled from 250 billion in 2022 to 807 billion in 2023. Sufficient allegation. Another one, Pbbm signed off on 9 SARO worth 213.8 billion. Sufficient allegation. Next, Pbbm used unprogrammed appropriation to circumvent congressional oversight. This is of course a conclusion. Parang legal treatise na naman po yung discussion dito on UA as insertions. Next, Pbbm approved special budget for UA projects. Sufficient allegation. Pbbm authorized 100 billion in FCPs for political patronage. This is a conclusion. So overall, a liberal treatment of this ground would favor a finding of sufficiency in substance, despite the plethora of conclusive allegations as opposed to factual allegations. Having these conclusions do not destroy the fact that there are indeed factual allegations, which when hypothetically admitted can establish a nexus to any ground, especially betrayal of public trust. Again, hindi pa po mga defenses of the possible defenses of respondent ang pinag-uusapan natin dito, kundi purely on the sufficiency of the allegations. Thank you.
Madam Chair.
We allow the manifestations of all the members of the committee, including all possible arguments, that is to guide all of us or the members as we vote this afternoon on the sufficiency in substance of both the De Jesus complaint and the Massa et al. Complaint, notwithstanding the significance of the observation of the other member on the manifestation. In our proceedings, we are actually encouraging them to give a better understanding of what we need to determine as we end the deliberation this afternoon.
Madam Chair. Madam Chair.
Is this in connection with the manifestation of the Honorable Dilemma? Because
Yeah.
we have a list, Honorable Adjunct,
Yeah, just a very short manifestation.
in relation to
Yeah,
her
yes,
manifestation.
just a comment.
The Honorable Adjunct is recognized.
Just a brief manifestation, Madam Chair. Madam Chair, I do completely understand and the observation and perhaps what the Honorable Congresswoman Laila de Lima would like to recommend for this committee to approach this current deliberation and current discussion that we're having right now. In particular, the assessment on how we value the sufficiency of substance of the allegations presented before us today. I do respect her views. In fact, Madam Chair, I do not even want to argue, perhaps, on the merits of what Congresswoman Laila De Lima laid out before this committee. She is known to be a legal luminary. We do value all her points. In fact, Madam Chair, the committee has been very liberal in trying to allow the former Secretary of Justice, former Senator, and our colleague to emphasize clearly what should have been the legal framework on how we approach the issue at hand, which is to assess, again, the sufficiency of substance of this matter. But then again, I would like to just point out, Madam Chair, that most of us here came out with our own manifestation and our position and observation, not necessarily to defend the respondent, Madam Chair. Because I believe that in this case, in particular, the President has all the legal resources. Should this proceed to another level, is more capable of defending himself. The individual observation and manifestation, Madam Chair, of many of our colleagues here are not defending per se the President, but this is also guided by the rulings of the Supreme Court, guided by the premise by which the Constitution laid out on how we approach impeachment proceedings. Number one, in my humble opinion, Madam Chair, first basic requirement that I would like to look into the allegation is if such an allegation established that there is bad faith in even trying to say that there is indeed an offense committed which constitute impeachable offense. The betrayal of public trust, Madam Chair, meron pong nakalay down doon kung ano yung mga ano, but ang para sa akin po, requirement is if there's really a bad faith. In this particular second allegation, kung may bad faith po dyan, ang nakita ko, Madam Chair, is that number one, the case of the Supreme Court over the unprogrammed appropriation is still pending. So we do not actually have a concrete response from the Supreme Court. That's number one. Number two is the initial ruling of the Supreme Court actually removes culpability on the DOH because the bad faith that was the bad faith, which probably would be the one to cite culpability on the part of the DOH, is absent according to the Supreme Court. There's no culpable violations or criminal violations for that matter on the ruling of the Supreme Court. So again, my humble opinion, Madam Chair, and again, I thank you for allowing me to say this, is the members who came out with their individual observations. Ang sabi nga po ng ating Senior Deputy Majority Leader, this is a political process. Allow our members to share their own opinions. We may not like what we hear from our members. We think that some of the observation assessment of our individual members might not even reach the standard of how we discuss legal matters in impeachment proceeding, but at the very least, allow them to express their own views without labeling it as something defensive to favor the respondent, in this particular case, the President. We are guided by the rulings of the courts. We are guided also by the premise by which the Constitution has laid down on how we proceed with impeachment proceedings, Madam Chair. Maraming salamat po and thank you very much po sa opportunity.
Let us all be reminded that we are the representatives of the sovereign people here, and that is why the Chair has been very liberal about accommodating all the manifestations and arguments which are being raised and presented by the members of the committee. Nevertheless, moving forward, we recognize the Honorable Rodriguez.
Thank you very much, Madam Chair. The second act of betrayal is found on page 23. The charge. President Marcos betrayed public trust by, very important word, abusing. Because betrayal of public trust, abuse. To solely, next issue, solely authorize the release of unprogrammed appropriations, channeling 213 billion in standby funds, and so forth and so on. So, abuse, and then solely. Now, let's go now to the next page. The legal framework that they provided already provides the ammunition why the president cannot be responsible. The legal framework states that precisely Section 35 of the Administrative Code of 1987 and the Special Provision number 1 of the 2024. They say establish an ambiguous is not big ambiguous because it's not ambiguous legal reality. The reality, according to them, is that the president personally controls the release of unprogrammed funds. Of course, being the chief executive, all the funds should go, especially under the law on unprogrammed funds. The law provides that the president will be the one issuing it. So already clear that the president is empowered by law, two provisions of law, Administrative Code and the General Appropriations Law. And then, 99, expenditures from this lump sum appropriation must be made in accordance with the special budget. You see, it's not solely the president. A special budget to be approved by the president because it comes first from the department, it goes to the DBM studies it, and then recommends to the president. He is not the sole. It's not out of nowhere, he will now release program funds. So, he, in fact, would support the fact that this particular ground has no sufficiency. Now, let's go to the judicial confirmation of abuse. Citing the case of Pimentel versus the House of Representatives, Special Provision 1D of the 2024 GAA, they say that this is a confirmation of abuse. I disagree. The Supreme Court struck down PD Presidential Provision number 1D. Why? Because the doctrine of operative facts, as early as 1971, second year, College of Law, 1977. The case of Serrano de Agbayani versus PNB already establishes the doctrine of operative facts. What is that? All the laws are valid and all acts of the executive or whatever official is valid until the law is declared unconstitutional. This case of Serrano de Agbayani versus PNB was followed by a litany of cases on operative facts, which are Belhica versus Ochoa Jr. and Bandadas versus Ochoa Jr. Now, Madam Chair, the operative fact means that everything, Secretary Recto has the authority because we have the provision of section of the special provision. We have a provision in our GAA that authorizes that excess funds of all government-controlled corporations may be remitted to the national government. Although he was wrong. They were wrong, but the law acknowledges that they were valid when they were transferred. In fact, the decision says that they are not responsible. Why? Because of the doctrine of operative fact. So therefore, Madam Chair, this entire charge falls under the doctrine of operative facts. Recto was right. Recto was doing what was right at the time it was not yet unconstitutional. The President was right in having this release because that is the doctrine of operative fact. So I'd like the complainants to read. Serrano de Agbayani versus PNB, 1971 case, 55 years ago. And is still now being done by all the decisions, including Pimentel III. So therefore, Madam Chair, how can we blame the President on this particular release coming from unprogrammed funds when they were legal with the special provisions being legal at the time, declared to be unconstitutional later on. So, Madam Chair, then let's go back to the others so that we can have the causal connection. Because all of this will fall already, but I'd like to just emphasize for the record. The causal link to corruption, here, this is now the vague statement that would make the signing of the President, the act of signing into law our GAA, which is deliberated by the House and the Senate, the signing will become an illegal act and subject to impeachment. This is what is stated in 104. By certifying the 2024 budget as urgent and signing it into law with special provision 1D, he is now therefore directly enabled and constitutional siphoning. At the time, it cannot be unconstitutional kasi wala pa nga. At the time that this was transferred, there was no declaration of unconstitutionality. Again, the doctrine of operative facts. So, then, after this, we go now to paragraph B, circumvention of congressional oversight. How can there be a circumvention when these program funds released are not anymore under the law subject back? Otherwise, every release of the President, the complainants would want the Congress to be the one to decide through oversight. How can we do that? There's just so many items in the program funds. And that's why the Chief Executive is given that power by law to be able to release. There is no, as far as we are concerned, oversight function that we can reverse the President. The old President can veto, and that is the time we can reverse him. But after that is signed, it is already law. So there is also nothing in paragraph B, circumvention of congressional oversight. Then we have again legal conclusions. You do not put in a complaint your legal conclusions. The judge will decide on that. Civil cases, there can be no legal conclusion because that is subject. That is why you are recital of facts, so that the judge, in this case, the Committee on Justice, will decide whether there is a basis to consider to continue with the trial or not. So, Madam Chair, clearly, the doctrine of operative facts absolves everybody in relation to unprogrammed funds. In relation to PD presidential of the special provision number 1 of the 2024. Doctrine of operative facts. As early as 1971, Serrano de Agbayani versus PNB. Moratorium case, the moratorium of non-payment of utang to the government on housing. So, all the collection were valid until it was declared unconstitutional. So therefore, Madam Chair, it is clear that there is no basis in fact to be able to proceed even hearing this case because everybody is absolved already. That is the law. And the law is read into all complaints. Thank you, Madam Chair.
What distinguishes a dean of College of Law from a lawyer? A lawyer knows the law, but the dean knows the evolution of the law.
No, the difference, Madam Chair, from a lawyer is that how to become a dean. A lawyer who does not know how to practice law, he becomes a law professor. And a lawyer who loses his cases and does not know how to teach, he becomes the dean of the College of Law, San Sebastian College of Law.
Thank you,
Madam
Honorable
Chair.
Rodriguez.
Madam Chair, I beg to respectfully disagree with
Okay, let's
Congressman
give
Rufus.
chance to break the monotony of this very
I disagree also,
heated
Madam Chair.
discussion. Let's give
36
chance
years
to
po ako.
another Dean, Dean Jokno, to react to the statement of Dean Rodriguez.
36 years po ako kung Rufus nag-practice bago po ako naupo.
Exception of
Dean.
Chil Jokno, of course.
Madam Chair, I
Thank
will
you,
be
Madam
signing the
Chair.
impeachment complaint of Congressman Jokno against Congressman Rufus Rodriguez.
All right, so let's move forward. We recognize the Honorable Vice Chair Dumogan.
Thank you, Madam Chair. Well, I do not like to repeat what already been narrated by the previous speakers. But let me go to the point why it appears in the allegations that there are a statement of facts. But to me, I feel that it's my function not to stop there but to continue because of our own rule that the complaint must be verified and based on personal knowledge of the complainants. It's not because there are allegations of facts, then we stop there and determine that it is sufficient in substance. No. We have to determine if they have the personal knowledge
on this one. That's our role requires. That's why, looking at the allegations on the second ground for betrayal of public trust, we say abuse of discretionary power over unprogrammed appropriations, paragraphs 117 to 180. Again, I do not see an evidence that will link the president. It's not defending the president, but to me, it's part of my function to find out if the complainant has the personal knowledge. If you look at them, based on newspaper clippings, we already said that in the case of the Sierto, Supreme Court said that newspaper clippings are more or less hearsay, second-hand information. And then, of course, the alleged confession of Saldico. That's not the confession of the complainant, or there's no allegation that the complainant was present when this was made. So, I hope my colleagues will understand why I still proceed even despite the fact that there are factual allegations already stated, but trying to find out whether or not the complainants have personal knowledge as required by our own rules. And let me point out that even in the complaint itself, it stated that, look, a lot of certain individuals and contractors are facing charges already. Investigations are going on. And this had been done by the act of the President of denouncing these anomalies. How can we now reconcile that and come out to a conclusion that he was involved in this one without any piece of evidence that will link the President to the commission of an impeachable offense? So I respectfully submit that on ground number 2, it is not sufficient in substance. Thank you.
Madam
Thank you.
Chair,
Thank
just
you,
a brief...
Vice Chair Dumoga.
Madam Chair.
In reaction to Vice Chair Dumoga,
Yes, Madam Chair.
please make this quick, honorable dilemma.
Thank you.
Thank you.
Thank you, Madam Chair. Only on the point of the verification based on personal knowledge. Remember that in our rules, it says based on personal knowledge or based on authentic records, and we can extend it further based on publicly available documents. Kasi po kung ganyan, lahat na complaint ay talagang siguruduhin na personal knowledge o i-require na based on personal knowledge, wala na po sigurong magpa-file ng impeachment complaint against anybody. Kasi itong mga ganitong mga issues, these are public issues. Nasa public discourse yan. So naririnig yan sa radyo, nababasa yan sa newspapers, information online, etc. So that's not strictly personal knowledge, but it's publicly available information as long as based on authentic records or publicly available information or documents. We cannot just be insisting all the time na dapat ay personal knowledge. Mahirap po yan. Wala na pong uusad na impeachment complaint kung purely based on personal knowledge ang kailangan i-allege. Take a look at all the impeachment complaints filed now. Ito pong dalawa against the President, and then yung dalawa so far against the Vice President. May iba doon, personal knowledge. But pangkalahatan, hindi po personal knowledge ang mga yon. Kasi mahirap na i-require nga na purely based on personal knowledge. Itong mga, including itong mga naka-allege po dito sa complaint. Of course, we based it on reports. We based it on testimony. Yung later po sa number 3, nandun yung mga supposed na mga claims ni Saldico, and then yung supposed na mga claims din ni former Yusek Bernardo, affidavit, testimony before the Senate. Those are supporting proof. Pero hindi sinasabi na totoo yung mga sinasabi ng mga nag-claim ng mga ganong facts. Marami po, lalo na sa ground number 3. Thank you.
Without disputing the manifestation of the Honorable De Lima, the Chair wishes to state for the record that the verification requires personal knowledge or authentic records.
Yes.
It's
Moving forward, Vice Chair Dumogan.
Madam Chair, it's or.
You have already mentioned, Madam Chair, that
All right.
it must be based on personal knowledge or authentic records. That's what our rules require. And as I was pointing out, I will not stop only on the establishment of the statement of facts, but we have to find out relation to the personal knowledge or authentic records. Which unfortunately, there is none here. That's my point.
With the indulgence of the Honorable De Lima and the Vice Chair Dumogan, we have a list. So we will be moving to the next speaker, the Honorable Benny Abante.
Thank you, Mr. Chair, Madam Chair. I truly appreciate the statement of Congresswoman De Lima on what she said. I listened very intently on that. No, pero I'm just wondering what abuse of discretionary power when it is not the president that actually approved the unprogrammed funds. He signed it because he has the discretionary power to do it. But I would not even think that he forced the congressman to approve such unprogrammed funds. Anyway, the title alleges abuses or abuse. But the complaint must plead facts, not only personal knowledge, but plead facts showing abuse, not merely invoke discretion. For example, the charge accuses the respondent of abuse of discretionary power over unprogrammed appropriations. But a charge is not made sufficient by a label. It must plead a recital of facts constituting the impeachable offense. I am not talking as a lawyer, but I am talking also as a logical man. You see? According to Section 25, Article 6 of the 1987 Constitution, and I quote, budget execution and disbursement operate within constitutional constraints, including limits on transfers, augmentation, and requirements that discretionary funds be disbursed only for public purposes, supported by vouchers, and subject to guidelines prescribed by law. I would think that the president knows all about this, including his economic managers. And because the Constitution regulates how appropriations may be used, therefore, a charge of abuse must identify, at minimum, what legal constraint was breached and what act violated it. Here, Binasa ko po yung lahat ng binanggit dito on the abuse of discretionary power, wala po ako nakita. No pleaded factual anchors. For example, the complaint does not allege the acts or omissions constituting the charge. On the face of the charge of abuse, Madam Chair, it fails to allege the key factual particulars that would constitute abuse, such as what unprogrammed appropriations was released or obligated, the amount and date, the project, the purpose and implementing entity, the recipient or beneficiary, and the specific constitutional statutory limitation violated. Without these particulars, sa pagkaintindi ko, the accusations remains a conclusion, not a recital of facts constituting the offense charge as required by the Gutierrez case. That's the reason why I still maintain insufficiency in substance as far as the second act of betrayal of public trust is concerned. Thank you, Madam Chair. Salamat.
Thank you, Honorable
Madam
Abante.
Chair.
Next in line
Madam
is...
Chair.
What is the pleasure of the Honorable Co?
Madam Chair, just to quickly respond on the manifestation of Representative Abante.
All right, you're recognized.
Thank you, Madam Chair. Madam Chair, in regards to a specific recital of fact on the alleged gross abuse of discretion, I would like